its time in this matter, Lordship.
Why?
No objection, Your Lordship. No objection, Your Lordship.
It's a very old matter.
Lordship, the conducting counsel is, she's having some personal difficulties, Your Lordship.
Miss, the counsel for the petitioner has sought for accommodation on the ground that the Learned Senior Conducting Counsel is indisposed on grounds of personal difficulties. The prayer not being objected to by Miss Learned Counsel for the respondent. Let us adjourn. List is here after 1 week.
Lordship,
1 week.
highly obliged.
Right, Your Lordship.
From supplementary list, item number 1.
Yes.
Your Lordship. Your Lordship, item number 1, 2, 3 and 4 are arising out of the same case, Your Lordship, and item number 5 is a different case. But in all these cases, Your Lordship, there was a question of maintainability raised. And on maintainability, my senior Dr. N. Mojika has concluded his arguments, Your Lordship, and he has placed his judgments as well, as per my instructions.
Nothing has been, this matter has not been heard.
Lordship, these are my instructions. On the last date, judgments were placed and our hearing on maintainability has concluded. So the other side has to reply today, Your Lordship. We have filed a compilation of judgments.
When was this matter heard?
Your Lordship, the last date was 7th of March, Your Lordship. ये तो कल था.
You see, this matter, time and again, accommodation has been sought for by one party or the other.
Yes, Your Lordship.
There was no effective hearing. Not that I recall. In any case,
Yes, Your Lordship.
going through the papers,
Yes, Your Lordship.
this court has noticed that this is an application essentially for cancellation of bail.
Cancellation.
And the case relates to provisions of the NDPS Act. If I recall vaguely, your senior must have pointed out that the prevalence of Section 37 has to be looked into. Apart from that, he has no strong objection as to the violation of the bail conditions.
Yes, yes, Your Lord.
Which was not the case.
Yes, yes, Your Lord.
Considering the fact that the respondents accused have been appearing in court from time to time.
They have been
and
appealing.
even now the court is in, the trial is progressing. So, if that is the case, I don't think you have any case.
Your Lordship. With regards to item number 3, Your Lordship, the person has
issue of
passed.
cancellation of bail,
Yes.
rather the question of cancellation of bail will come only if there is evidence of violation of bail conditions. Either the accused is a flight risk, never appeared, violation of certain conditions like bail bonds and all those conditions, but not evident in this case.
Your Lordship.
Heard, Mr. Counsel for the petitioner. who has submitted that this application preferred under section 439 2 read with section 482 of the CRPC is basically a challenge against an order dated 17/1/2023 passed by the High Court of the Special Judge NDPS in bail application number 11H of 2023 connected to special under bracket NDPS case number 2 of 2022, wherein the respondent herein was granted bail. The Learned Counsel would submit that the main thrust of the petitioner is with regard to the alleged non-consideration of the Learned Trial Court as to the applicability of section 37 of the NDPS Act when the said impugn order was passed granting bail to accused person, to the respondent oblique accused person herein, maintaining that non-consideration of such provision would negate the very essence of bail jurisprudence as far as NDPS cases are concerned. Therefore, the impugn order may be set aside and quashed, and the bail granted be cancelled. Anything else, Dr. Musika?
Only count. Well, as far as maintainability, my lord, your lordship, because I have placed so many decisions.
You have no case at all. So, question of even if it is maintainable,
My lord.
your case will still go.
Well, maintainability only some observation, but it is maintainable, my lord. I cited so many decisions from last time.
The question of maintainability will not come. Order will pass.
We'll leave it open, my lord. That observation.
Why? If you are challenging the process as such, then the maintainability will come when you have questioned the very jurisdiction of the court which has passed the order. But here is, apart from your focus on section 37, as far as cancellation of bail is concerned on alleged violation of condition, that does not arise. There's no apparent evidence on that score.
My lord, what I'm trying to submit, my lord, on last occasion, because they challenged the maintainability of 482, my lord. On that I placed certain decisions, my lord. Or lordship may say without going into the maintainability, my lord.
There are no. Who's appearing here in this case?
234 I am appearing, your lordship.
Or you're the first? Next one. Mr. S.S. Yadav, Learned Counsel for the respondent, in response, comma, at the outset has challenged the maintainability of this application under section 482. He, however, has also submitted that there is no question of cancellation of bail, of the bail granted to the respondent oblique accused, inasmuch as there is no evidence of any of the bail conditions being violated by the respondent accused, and as such, and under such circumstances, the question of cancellation of bail does not arise. In fact, the records would show that the respondent accused has been diligently attending the trial court as and when the case is listed, and has not obstruct its proceeding in any manner. Accordingly, it is prayed that this petition may be dismissed as devoid of merits. This court has considered the submission made, even without taking note of the issue of maintainability, which may not be decided at this juncture. But what is apparent is that there is no contradiction to the submission of the learned counsel for the respondent as to the conduct of the respondent accused while on bail, thereby meaning that none of the bail conditions set out in the impugned order has been violated. Thanks. The essence of cancellation of bail is rooted in the fact that the conduct of the accused, the fact that the accused person has violated the bail condition, or that while on bail he has indulged in similar kind of offences, or that the accused person is a flight risk which would prompt the court to cancel the bail granted. Such factors are, however, not evident in the case in this case. Accordingly, this court is of the considered opinion that the petitioner oblique Union of India has not been able to make out a case for setting aside or quashing of the said impugned order. Prayers therefore rejected. Petition disposed of.
Deeply obliged.
So there will be similar orders.
Similar, only my lord, number 3, I think the accused person has died, my lord.
Yeah, number 3, I have filed affidavit, your lordship.
So that becomes
Item number 3, Neetu Sharma.
We can
I
cancel,
mentioned yesterday also, your
we
lordship.
can cancel his bail. He has become a flight risk.
Yes, your
He
lordship.
has fled from this world. What can we do? Katuka number 3.
Oh, my lord, we observe that trial court will take note of that death of Neetu Sharma.
Yes, that,
Yeah, I have filed there also. I have filed.
that would be proper, because then his presence would be awaited.
Yes,
as far
sir.
as the
I have filed there already, Lords.
next. Then the counsel for the parties, Mr. Escobar, learned counsel for the accused, for the respondent accused, has submitted that the accused is since deceased, and an affidavit in this regard has been filed, enclosing the death certificate. The accused person is said to have expired on
29/12/2024.
29/12/2024. Accordingly, it is prayed that nothing survives in this case as far as the accused person is concerned, and necessary orders may be passed. Dr. N. Muzika, DSGI, has conceded to the prayer made, but has, however, submitted that while disposing of this application, the trial court may be directed to take cognizance of this fact, of the fact that the accused is since, the respondent accused is since deceased, and to pass necessary orders in the trial, in the case against the accused. Accordingly, on consideration of the prayer made, or of the submission made, this court hereby dispose of this petition as infructuous, on the ground that nothing survives against the respondent accused, who is since deceased. As submitted, the learned trial court is to take cognizance of this fact and to pass necessary orders as far as the trial is concerned. Petition disposed of.
Duplio.
Your Lordship, only in item number 5, case date will be different. Impugn order and case number.
It will
Daily list, item number 1.
Please, Your Lordship. As per the last order, Lordship, the petitioner was supposed to file affidavit of service, Lordship. I didn't get a copy.
Yes, have you done?
I've already served the state, Your Lordship, a copy of the affidavit of service of confirmation.
You filed it.
Already filed, Your Lordship. Today, Your Lordship, it's listed for hearing.
Please, Your Lordship. Hearing.
On the last occasion, you have made a prayer to file the affidavit of service.
I have already filed, Your Lordship.
Please show me, please.
What is the stage of this case?
Your Lordship, as of yesterday, Your Lordship, it was fixed for the appearance of the accused person, Your Lordship.
Charges have been framed.
Charges have already been framed, Your Lordship. Your Lordship, even the 164 statements of the complainant and the victim also have already been recorded. Your Lordship, even the evidence before the special court of the victim and the complainant has also been recorded, Your Lordship.
Have you annexed all those?
I have annexed, Your Lordship.
May I please, Your Lordship?
Yes.
Lordship, since the matters are listed for orders today, and also since the matter is being led by the additional Advocate General Lordship, Mr. K. Khan, Lordship, and he's indisposed today, Lordship, and
We'll take it up tomorrow.
Lordship, me listed for hearing tomorrow.
Miss, I heard Miss D.F. Mauri, counsel for the petitioner, who has submitted that pursuant to this court's order dated 10/3/2025, the affidavit of service as far as the notice issued upon the respondent 2 is concerned has been filed, indicating that the said notice has been duly effected. This was done after confirmation from the portal of the post office, copy of which is annexed with the said affidavit. The respondent 2 is not in appearance, has not made any appearance before the court today. Mr. H. Karwalang Larat, you also additional PP.
It's Lordship.
Additional PP has something that this matter may be, that the hearing of this, that this matter may be posted for hearing. Accordingly, on prayer made, this is matter for hearing tomorrow.
May I please, Your Lordship? Lordship, I'm appearing for respondent 1 and 2, Lordship. The private respondent is respondent 3.
Yes. Paying for respondent 1 and 2. 1 and 2.
Yes,
also
Lordship.
respondent 3 to you more.
Lordship.
Item number 2.
My lord, in this matter, Mr. Kenta appeared earlier, my lord, for district council. Now he is informed that he will not appear because of change in dispensation, my lord. So, my lord, will
No, affidavit, counter affidavit has been filed.
no.
So far as state is concerned, we file
State is
a
filed, my lord. District council is not filed.
District council.
And last occasion, Mr. Kenta appeared, my lord.
Oh, this is that check gate.
Check it, my lord.
Now
Now,
notice be
so we'll serve a
issued.
fresh copy to district council, my lord.
Yes.
Dr. N. Muzika, senior counsel appearing for the petitioner, has stated at the bar that the learned senior counsel, Mr. B.J.K. Kanta, who had earlier appeared for the respondent number 6, is said to be is no longer appearing on behalf of the said respondent. Accordingly, it is prayed that fresh notice may be allowed to be served upon the respondent 6. We allow that notice be issued, returnable within 2 weeks.
1 week.
Apply, Lordship.
1 week.
1 week. We'll take the justice service, my lord. We'll serve in the office directly.
Within returnable within 2 weeks, as prayed for, the to be served by Dusty. As prayed for, this is matter to 1 week.
Apply, Lord.
Item number 4.
Petitioner is to file a rejoinder affidavit, Lordship.
Sure, I need some more time, Your Lordship, to file my rejoinder, Lordship.
This matter has been listed in the hearing column.
The hearing is Your Lordship.
But in the process of hearing the instant matter, Lordship, we had filed a certain affidavit before this honourable court, and the petitioner sought time to file the rejoinder, Lordship. And this was allowed by this honourable court, Lordship, on the last date, on 10th of March. Now, this is second prayer, Lordship, second time.
So, have you filed?
No, Your Lordship. I need some more time, Your Lordship, to file my rejoinder.
How long?
2 weeks, Lordship.
Mr. Learned Counsel for the petitioner has sought for some more time to file the rejoinder affidavit.
4, 5, 6, 7, 8.
You have filed an additional affidavit.
Lordship, as per instructions received from the department, the block lordship, we had to file it by way of an affidavit, Lordship. When we brought the same before this honorable court,
No, you see, as far as the main, the main petition is concerned,
Lordship,
uh,
we filed an affidavit.
you have filed the counter
Lordship,
affidavit.
Lordship.
Thereafter, you file another affidavit.
Certain queries were raised by this honorable court, Lordship. So by way of a document, we had informed this honorable court the same, and this honorable court was of the opinion that an affidavit be filed according to the response received, Lordship. So we did that, Lordship, and they had sought time to file the rejoinder.
It should have been an additional affidavit.
Lordship, what we had filed was an affidavit in compliance with the order dated 27th of November, Lordship.
Otherwise, it becomes very confusing.
Very true, Lordship, true.
Kumnum Tomo? Rejoinder affidavit to the affidavit dated, when was the affidavit filed?
14th of February 2025, Lordship.
Dated 14/2/2025, filed by the state respondent. Only the state respondent.
State, my lord.
State respondent. Any private parties here?
Private parties are there, Lordship.
Who's appearing?
Mr. Armaja, Your Lordship, for respondent number 6.
6. Nobody has appeared. But this respondent has not filed any affidavit.
No, Your Lordship, he's a pro forma respondent, Your Lordship.
Accordingly, as prayed for, this is matter after 2 weeks.
Lordship, 4, 5, 6, 7, 8 are connected, my lord. Same order, Lordship.
Same order.